Welcome into the Cheeley Law Review. My name is Ben Burnett. I'm sitting here with Bob today. We want to talk about the order of proof.
The order of proof. It's like real-world comparison would be going to a play, like a Shakespearean play. Shakespeare wrote some incredible plays. He had different characters play different roles, and he brought them onto the stage at different points in time, building up to the climax of the play and point of the whole story. What I try to do, working with the other attorneys here in my firm and the paralegals, is really give a ton of thought to, okay, who do we call and in what order at trial? And what's our purpose for calling a particular person to take the stand? I have this theory after starting this whole process back in 1982, trying cases, that the best case is a fast case to try, because jurors get bored if you drag a case out. They can tell when you're dragging and asking the same questions to different witnesses and repeating the same answers that they previously heard. I want to show respect to the jurors, that our questioning is going to be tailored, it's going to be focused, it's going to be efficient to each witness. And I want to get that witness on and off the stand as quickly as possible. I don't want to drag it out. So we start off with a whiteboard. These are the things that we absolutely have to prove in this case. These are the witnesses that we can prove those facts by. In what order do we need to present them? I like to start off with the first or second witnesses being like in a heavyweight fight. I want it to be a knockout early in the trial so that by the time the jury's heard from those first few witnesses, they've got their mind made up. There's no way for the defense to counterpunch on these first few witnesses. This all ties back into what
It sets the tone.
It sets the tone. It's a great thing to see when a good plan comes together, because inevitably, when at the beginning of a case, the judge is going to ask both sides, how long do you think it's going to take to try this case? The judges will typically know that. They'll ask us 3 or 4 months in advance of the trial, how many days do I need to reserve, set aside to try this case, and bring in the jury that can serve. And so we try to determine as best we can, all right, we're going to be putting up 8 to 15 witnesses typically in a trial. Some of the more complicated ones, you might get 30 witnesses. That's the exception rather than the rule. But I want to plan out as best I can my questioning for each of these witnesses. I want to identify the evidence that's got to go in by each witness, and then figure out, okay, how can I question this witness to get in these documents or this evidence in as few questions as possible. A lot of times when I tell the judge we can put up our case in 2 days with 19 witnesses, they're like, what? Just learn to really focus in, rifle shot the questions, and don't waste the jury's time. I've found that a lot of times the defense lawyers will wind up spending more total cumulative hours cross-examining each of my witnesses than I've used to put the witnesses up on direct examination to ask them the questions that I wanted to get.
To build a case.
To build the case.
How often, as a plaintiff's lawyer, does it go 100% according to plan?
I don't know that I can say it goes 100%. Sometimes it does, rarely, but I would say generally I'm in the 90% range.
So you walk in there, when you start calling witnesses, you know where you were headed.
Yeah. I grew up playing high school football as an offensive left tackle, and I love to open holes so the running backs can get through. My goal in a courtroom is to go in there and pancake block every defense that I've heard in discovery leading up to trial. And I want to pancake each of those defenses in the first 2 or 3 witnesses and destroy them. And then watch my running back run down the field and score.
Take the other side of that. What type of research goes into the witnesses that the defense is going to call? Or is it a relatively textbook, emblematic type of relationship? You've seen one, you've seen them all. Talk about how you get prepared on the other side of that.
All right, so in discovery, that's the deposition phase of the lawsuit leading up to a trial date and to a jury trial. We know who the defense is going to call as witnesses, or the list of people they're going to have to choose from. And so we try to do as much research on that person as we can. And sometimes we'll find something really good that person who may be an expert witness, for example, that testified in another deposition that we found that another lawyer may have taken in California or Michigan. And we can use that to impeach that witness when he's on the stand. And I've had so much fun with that over the years when
they've said something in one place and then something different in another.
Totally different.
But they're under oath.
Oh yeah, but these people are paid, a lot of money. These are typically in the cases involving.
The idealistic part of me does not like this.
Yeah, but there are people that are with some expert services groups around the country that will say anything.
Pay for play.
Yeah, they will say anything to help their client either get off or fight back against the plaintiff's experts. So, but it's really a lot of fun. I'll give you an example. In one case years ago, I had a case involving a helicopter issue, and my client was a burned patient on a helicopter that crashed in a hospital parking lot in Gwinnett County. That helicopter should have never landed in that parking lot in Gwinnett County because of the light poles in the parking lot.
Sure.
But that's what they wound up hitting when they took off with my client on board. The defense called a helicopter landing pad expert, and who came in to say, "Oh, there's no problem landing in a hospital parking lot." But I had found out that the particular expert witness who came in to give that opinion had himself crashed a helicopter and ran out of fuel flying it from South Carolina to Atlanta. He was coming into court to testify about, this was the helicopter pilot's fault, pilot error. And so it was really fun to be able to bring out the fact that, you're a helicopter crash expert, aren't you? You know how to crash one, and failed to make sure that I had enough fuel on board before you took off from South Carolina to Georgia.
Well, this has been another episode of the Cheeley Law Review. We will see you guys next week.